Senator Warren has noted, issues important to our country. And I, in the context of talking about Ryan Bounds, am going to talk about how, unfortunately, the handling of the Bounds nomination moves the Senate even further away from what I think the Senate has always been about, which I would describe as principled bipartisanship. Now, as I indicated, Ryan Bounds, an important judicial nominee, is being considered as a candidate from my home state of Oregon, and we will vote on him here before the end of the week. And before I begin my remarks, I'd like to ask unanimous consent that the following individual fellows in my office be granted floor privileges for the remainder of the Senate: Casey Dreer, Kathleen Carlson, Nick St. Laurent, Gabe Kapchuk, Shannon Shah-An-Nan-Kauni, Roberta Knest Dager, and Derek Southern. I would ask unanimous consent that all of them be granted unanimous consent to come to the floor, and all of them, Mr. President, accept my apologies if I have pronounced any of the names inaccurately.
Without objection.
Thank you very much, Mr. President. And as I've indicated, I believe that the debate about Ryan Bounds is not a typical debate on a typical nomination for reasons I'm going to outline tonight. And in my view, it is vital that the Senate look at this nomination in a broader context, particularly as it relates to what I call the decline of principled bipartisanship here in the Senate. And I want to be clear about what I mean when I mention the word principled bipartisanship. And the reason I describe it that way, bipartisanship born of principle, bipartisanship is not about taking each other's bad ideas. I see my friend in the chair of the President of the Senate from South Dakota. I wouldn't come up to him in the name of bipartisanship and ask him to take a flawed idea, and I'm quite sure he wouldn't ask that of me, because I know the President of the Senate well enough to know that he's had an interest over the years in bipartisanship built around principle. So bipartisanship is not about taking each other's lousy ideas. It's about taking each other's good ideas. And the fact is, the Senate has certainly been very polarized, very divided this session, and yet we've been able to do it when we kept that lodestar of principled bipartisanship in mind. If you had said, Mr. President, in January of 2017, that the United States Senate would enact a 10-year children's health insurance program, an improved, expanded children's health insurance program, I think people would have said, you're hallucinating. It can't happen. But because my colleague who sits right over there, Chairman Hatch, and I talked about here was a chance to help children and save money, we were able to do something nobody thought was possible, because both of us shared an interest in the well-being of children and cost-effective approaches in health care. Mr. President, I know my colleague knows about this. Senator Crapo, who sits a few seats from Chairman Hatch, Chairman Crapo, he and I lined up more than 270 forestry groups because the whole system of fighting fire was broken. And we said we've got to do something very different. We've got to end the incentives, basically, for raiding the Fire Prevention Fund to put the fire out, and then the problem got worse. Didn't make any sense in South Dakota, didn't make any sense in Oregon, didn't make any sense anywhere. But because Chairman Crapo and I found common ground around principles, that this wasn't a cost-effective approach to discriminate against fire prevention, and we saw how important it was to take a balanced approach on natural resources so we could have forest health and get fiber to the mills and protect our land, air, and water. It was an agreement based on principled bipartisanship. So two big issues, not immigration or trade that are in the headlines, but an awful lot of people in America and in our part of the world are going to benefit from the principled bipartisanship that led to an unexpected breakthrough in terms of meeting the health care needs of our children and a transformative approach, not my words, the words of the Forest Service, in terms of fighting fire. The fact is, the handling of these judicial nominations, and Ryan Bounds in particular, is a break, a dramatic, sharp break from this tradition of principled bipartisanship. And I'd like to say, by the way, Mr. President, that in Oregon, we have followed the idea of principled bipartisanship as it related to judicial nominations as well. I've had the pleasure of working with two Republicans very closely on these judicial nominations. The late Mark Hatfield, a revered figure in Oregon, the chairman of the Senate Appropriations Committee, and my former colleague Gordon Smith, two Republicans. Nobody ever thought Gordon Smith and I would work together. We had had a race in 1996. I won by a little bit. He won the next one. Nobody ever thought that we would work together, but we worked together on those judicial nominations, literally hand in glove, a Democrat and Republican. Senator Merkley, who defeated Senator Smith, brought exactly the same approach to this. And he said, well, how did it work in the past? And I said, well, we had a judicial selection process that was bipartisan. And we'd have all our offices represented. And I remember when I was the junior senator and Mark Hatfield was the senior senator and Bill Clinton had been elected, I said, Senator, I can't imagine that you and I aren't going to find common ground through our selection process and the effort to come together around judges that made sense for our state and our country. And we did. And year after year, that's been the case. For almost 20 years, Mr. President, I've been the senior Democrat in our congressional delegation. It's been an extraordinary privilege that the people of Oregon have afforded me. And year after year after year, we would come together, not because we always agreed on someone's philosophy or their view on a particular issue, but because we felt in the name of fairness and principled bipartisanship, we ought to strive to find common ground and make it possible to generally send 3 nominations to the White House that a president would pick from. The nomination of Ryan Bounds is a total rejection of the idea of principled bipartisanship. And I'm going to talk a little bit more about how the selection process works, but I want to begin by making clear that I'm troubled by the incendiary, intolerant writings by Mr. Bounds that came to light only after he was nominated. And I am, in fact, even more troubled by the fact that he concealed those writings from the independent and bipartisan Oregon committee that reviews potential candidates for nomination. In my view, moving forward with this nomination in the face of those revelations is going to have regrettable and irreversible consequences. It not only tramples on Oregon's bipartisan judicial selection process, as I'm going to outline, and my colleague from Oregon already has touched on this. It tramples on a century-old tradition of what is just collegiality, good relations among senators, courtesy, allowing home state senators to review judicial nominations. My view is that this approach cheapens the constitutional responsibility of the Senate to provide or withhold advice and consent on nominees. It has the potential to forever lower the basic standards of honesty and decency to which the Senate holds a nominee. It will be a signal that a nominee can conceal information the public has a right to know, histories of prejudice and scorn that potential nominees could find embarrassing and disqualifying should that information come to light. And it signals that the Republican majority believes the end justifies the means in the course of seating judges, a prospect that certainly speaks to the larger debate that the Senate's going to have on the Supreme Court in the months ahead. So I'm going to begin by walking through a number of the issues, beginning with excerpts from the writings that Mr. Bounds failed to disclose to our bipartisan Judicial Selection Committee. I want to make it clear again, Mr. President, I find much of what was written to be disgusting and baffling, and I am, again, especially concerned that it was concealed from the committee. First, a passage in which Mr. Bounds targeted ethnic minorities and expressed a dripping disdain for multicultural values. Mr. Bounds wrote, and I quote, "During my years in our multicultural Garden of Eden, I have often marveled at the odd strategies that some of the more strident racial factions of the student body employ in their attempt to, quote, heighten consciousness, build tolerance, promote diversity, and otherwise convince us to partake of that fruit which promises to open our eyes to a PC version of the knowledge of good and evil." Mr. Bounds said, "I'm mystified because these tactics seem always to contribute more to restricting consciousness, aggravating intolerance, and pigeonholing cultural identities than many a Nazi," talking about book burning. Now, Mr. President and colleagues who are following this, I am the child of Jewish refugees who fled Nazi terror in Germany. Not all of our family got out. We lost family at Theresienstadt. One of our very dear family members was gassed at Auschwitz. To compare, as Mr. Bounds did, the work of organizations that promote multiculturalism and tolerance here in the United States to Nazi book-burning rallies is beyond extreme. Our diversity is a core strength of America, and the Constitution protects the rights of minority Americans to celebrate their diversity. Mr. Bounds clearly doesn't see it that way. Now, in an even more sarcastic passage, he wrote, and I quote, "The opponent is the white male and his coterie of mean-spirited lackeys, Oreos, Twinkies, coconuts, and the like. He enjoys making money and buying material things just to make sure people with darker skin don't have access to them. He enjoys killing children and revels in the death of minorities. If you're white, male, pro-choice, for instance, it's often ascribed to your desire for poor black and Hispanic women to abort their children as frequently as possible." Unquote. These are his words. Words that invent an absurd sense of victimhood based on a fictional reading of how ethnic minorities view others. I would just ask my colleagues, how can somebody who wrote and published statements like those, statements that were printed in Stanford's newspaper for anybody to read, be capable of hearing a case involving matters of race in an impartial fashion? After intoxicated athletes vandalized a gay pride monument at Stanford, Mr. Bounds wrote, and I quote, "We hear of sensations of personal violation and outrage and of suspicion that male athletes and fraternity members are bigots whose socialization patterns induce this sort of terrorism. Perhaps all of this is true, but the castigation of athletes and frat boys for flagrantly anti-homosexual prejudices is predicated on a motivation for this vandalism that has not been articulated." He continued, and I quote, "The vandals might face hate crime charges, fraternity members, regardless of their individually demonstrated prejudices, or for that matter, sexual orientation, face mandatory sensitivity training." And sensitivity insinuates itself a little further into the fissures of our community. So in that passage, Mr. Bounds somehow managed to make victims out of homophobic vandals and attack the concept of sensitivity as the source of division in American society. It's as if he believed being sensitive to minorities who are the targets of hate and prejudice on a daily basis was an unreasonable prospect. Next, I'll turn to Mr. Bounds' views on sexual assault on campus. Here he wrote, "There's nothing really inherently wrong with the university failing to punish an alleged rapist regardless his guilt in the absence of adequate certainty. There is nothing the university can do to objectively ensure that the rapist does not strike again." He continued, "Expelling students is probably not going to contribute a great deal toward a rape victim's recovery. There is no moral imperative to risk egregious error in doing so." Now, Mr. President, I'd be the first to say a disciplinary proceeding at a university is not a courtroom. They don't operate under the same legal standards. However, universities that receive federal dollars do have a legal obligation to protect the young women on their campuses. Once again, this is something that the nominee, Ryan Bounds, seems not to comprehend. So when you take these writings together, the merit of diversity, the advancement of ethnic minorities, the protection of survivors of sexual assault, these are issues at the heart of some of the most significant cases that come before federal judges. Mr. Bounds' writings reflect that he held shocking views on these matters as a young adult, views that he hid by concealing the writings I've touched on. There are plenty of inflammatory examples beyond those I've quoted here today, and they touch on additional topics. I hope senators and those following this would find my judgment not something you can debate. This is indisputably appalling stuff. Now, I believe, having talked to some colleagues, they might want to dismiss the writings because they came when Mr. Bounds was a young man, and one would certainly hope that people mature as they age. I would agree with that if Mr. Bounds had done two things. First, if he had disclosed the writings to our independent and bipartisan Oregon committee. In other words, been candid with the bipartisan and independent committee like the Oregonians who came before them for close to 2 decades. I don't think that's asking too much. To be candid, to be straightforward, as those other Oregonians who went on to distinguished service on the federal bench did for almost 2 decades. And in addition to disclosing these writings to the independent and bipartisan committee, if he had recanted and apologized for these horrendous remarks. In my view, he has failed to take either action. Now, when you think about this, nobody would ask Mr. Bounds to recant every utterance, every writing, every belief he held as a young adult. I think we all widely think that was unreasonable. And I understand that when there's a Republican in the White House and a Republican in charge of the Judiciary Committee, I'm not going to see eye to eye with every judicial nominee who comes up for a vote. And that's why I have gone to some length tonight, Mr. President, to mention that it's the senior Democrat for essentially 2 decades, whether it be Mark Hatfield or Gordon Smith, 2 very thoughtful Republicans, and now our colleague Jeff Merkley, we've always tried to be deferential in trying to find common ground and recognizing what party was in the White House and what party controlled the Senate. So I'm not asking Mr. Bounds to transform himself into Thurgood Marshall. It's completely reasonable to expect an admission that comparing the promotion of diversity to Nazi rallies was wrong. I can only imagine, Mr. President, what my late parents, both of whom fled the Nazis at a very young age, and all they wanted to do was to serve in our military, wear the uniform of the United States, my dad writing propaganda pamphlets that we dropped on the Nazis. I can only imagine what my parents would say to Mr. Bounds' idea of comparing diversity to Nazi rallies. Dismissing the value of diversity was wrong, and insisting that it's not worth protecting the victims of sexual assault because it's impossible to guarantee safety from rapists was wrong. But instead, Mr. Bounds hid these writings rather than recant, take back their contents. The comments he made since they came to light, in my view, suggest Mr. Bounds sees this as a matter of clumsy word choice and youthful indiscretion. He only really wrote about it after he it became a threat to his nomination, I don't think it was a true apology. It's as if he believes he can wave the writings off as a messy, isolated little episode from the past. In my view, and something I'm going to talk about going forward, Mr. President, nominees for the federal bench must be held to a higher standard. If you're up for a lifetime appointment on a powerful federal court, you have to be truthful and forthcoming in your nomination process. Ryan Bounds has not, and that ought to be a reasonable judgment from what I have outlined thus far. Now I want to touch on the second important issue, and that's the way this nomination has literally trampled on our bipartisan selection process for judicial nominees. And as I've said, Mr. President, I am proud that for the better part of 2 decades, prospective judicial nominees have been identified and vetted by our bipartisan committee made up of Oregonians from across the state, from all over the legal community. And as I indicated, it was especially important to me to partner with my Republican colleagues to ensure that all sides had a voice in this issue. In fact, even before I came to the Senate, because I was the senior Democrat in our delegation, then as a member of the House, I always wanted to hear Senator Hatfield's views, to talk about what he thought was in Oregon's interest. When there has been a vacancy on the bench, our selection committee performs a thorough statewide search for candidates. It conducts very rigorous interviews. It provides a list of recommended potential nominees to Oregon senators. Senator Merkley and I review these recommendations closely, and we respect that not everyone on the list is going to be somebody we would have chosen ourselves. They're not all people we would agree with 100%. After our review, the 2 of us submit a short list to the President for his consideration. For us, this is the beginning of how we put advise and consent in practice. And when the Trump administration came to office, Senator Merkley and I wrote to the White House counsel to guarantee he was aware of our longstanding bipartisan selection process. As part of the independent committee's work, candidates are asked to disclose anything from their past that could have a negative impact on their potential nomination. It ought to be obvious to any lawyer, even to anybody with a casual interest in American law and history, that the incendiary writings, particularly about minorities, would qualify as potentially threatening to a nomination. This was the exact point at which Mr. Bounds withheld any and all information about his writings. Now, it's not as if Mr. Bounds simply declined to look back far enough into his past when he was interviewed. In fact, Mr. Bounds cited certain activities from his pre-college days going back to high school in an effort to paint a picture of diversity and tolerance. So the reality is he misled the committee by omitting the writings that I have described tonight. When his writings came to light in February, 5 of the selection committee's 7 members, including the chair, said they would have changed their decision to include Mr. Bounds among their recommended candidates. And I think that's a really important statement, Mr. President. It's not widely known. It always will say in the newspaper, the distinguished President of the Senate recommended so-and-so. the president chose his recommendation. We know that that's generally not the case. We forward a list of individuals, usually 3, that our bipartisan committee felt would be qualified to serve on the bench. And in the case of Mr. Bounds, when his writings, the ones that he neglected to tell the committee about, came to light, 5 of the selection committee's 7 members, including the chair, said they would have changed their decision to include Mr. Bounds among the recommended candidates. Our bar association, our local bar association, wrote that Mr. Bounds' writing, and I quote, expressed insensitive, intolerant, and disdaining views toward racial and ethnic minorities, campus sexual victims, and the LGBTQ community. The association statement went on to say that it, quote, strongly disavows the views expressed in those articles, the ones I have read tonight, Mr. President, as racist, misogynistic, homophobic, and disparaging of survivors of sexual assault and abuse. I'll repeat that last part. Racist, misogynistic, homophobic, and disparaging of survivors of sexual assault and abuse. Those are not my words. Those are the words of Mr. Bounds' local bar association based in Portland. The association, in addition, requested Mr. Bounds resign from the chairmanship of its Equity, Diversity, and Inclusion Committee, which he complied with. Other member groups of the Oregon legal community added their voices and urged the leaders of the Judiciary Committee to turn to other potential nominees. The leaders of the Oregon Women Lawyers and the Oregon Asian Pacific American Bar Association wrote the following. These were not comments from the Twitter sphere or errant social media posts. They were well thought out, carefully constructed, published articles in which Bounds repeatedly diminished, mocked, and advocated wholeheartedly against the principles of inclusion for which our organizations have fought. Mr. President, that's really an important point. Mr. Bounds wasn't sitting down at his laptop, his iPad, and pounding out a couple hundred characters. He was thinking carefully in published articles that he clearly spent a lot of time trying to get the words so it reflected what was on his mind, and people have recognized it. No 280 characters for those articles. The Oregon Hispanic Bar Association, the LGBTQ Bar Association of Oregon, wrote the following. We believe Mr. Bounds' failure to disclose those writings and his conduct related to their disclosure demonstrates that Mr. Bounds does not show the appropriate judgment and discernment to faithfully uphold and apply the laws of the United States of America. These, Mr. President, are the voices of Oregon's legal community. The nominations process is supposed to be responsive to those voices. Apparently, none of what I have gotten into tonight has been of any interest whatsoever to the chairman of the Senate Judiciary Committee, the majority leader, or the White House, because they simply moved forward with the Bounds nomination anyway, and really there was no substantive discussions with them at all. It appears now that the White House simply had no interest in respecting the bipartisan 20-year-long history of tackling these nominations in a way that reflects principled bipartisanship. Mr. Bounds was their choice from the beginning, and no revelation, no red flag, no matter how big, was going to change them. So, our independent group of experts, people with bipartisan roots that go back decades, had no interest in delay. But, Mr. President, if blowing up a decades-old bipartisan tradition is bad, then blowing up a tradition that dates back more than a century is even worse. For 101 years, going back to Chairman Charles Culberson of Texas, the Judiciary Committee has sought input from senators on judicial nominees from their home states. It's done by returning what are known as blue slips. It is the definition of senatorial collegiality, courtesy, if you will, an effort to make sure that all felt they were going to be heard. The committee sends blue slips out to home state senators when a nomination comes up. At that point, the home state senators have a few options. Once they review the nomination, they can return the blue slip with a positive or negative recommendation. The committee moves forward. Or the home state senators can withhold the blue slip. Senator Merkley and I withheld our blue slips. We have not consented to a hearing, a markup, or a debate on the floor. And the reason we have done that is because Mr. Bounds purposely misled the independent Oregon committee that reviewed his candidacy by concealing the disturbing writings from his young adulthood. In my view, that's exactly the way the blue slip process is supposed to work. History shows that this tradition has benefited both sides as a check on the power of the president and a moderating democratic force on the judiciary. It helps to ensure that administrations are not seating flawed nominees or extremist judges whose views are simply far from the mainstream of the lives that they have considerable power to change if confirmed. In fact, let me quote a letter from the entire Senate Republican Conference sent to the last president at the very beginning of his term in 2009. What that means is that whole side of the chamber in 2009, every member of the Senate Republican caucus sent to President Obama at the beginning of his term in 2009 a letter with one of the very first lines saying, "Unfortunately, the judicial appointments process has become needlessly acrimonious. We would like to improve this process, and we know you would as well." So, at a time when this side of the chamber, everybody over there was out of power, and they had no choice but to appeal to the other party's goodwill, they went ahead and struck a bipartisan chord. Their letter described the nominations process as shared constitutional responsibility. They wrote that dating back to the nation's founding, the Senate has, quote, been a unique constitutional responsibility to provide or withhold its advice and consent on nominations. The principle of senatorial consultation or senatorial courtesy is rooted in this special responsibility, and its application dates back to the administration of George Washington. They continued, and I quote, "Democrats and Republicans have acknowledged the importance of maintaining this principle, which allows individual senators to provide valuable insights into their constituents' qualifications for federal service." And here is the heart of the letter that came from this side of the body. "We hope your administration," this is all of my colleagues on that side, on the Republican side, "we hope your administration, the Obama administration, will consult with us as it considers possible nominations to the federal courts from our states. Regretfully, if we're not consulted on and approve of a nominee from our states, the Republican conference will be unable to support moving forward on that nominee." So there you have the heart of the fury that we represent tonight, Mr. President. When a new Democratic administration came into office, my Republican colleagues sprang into action to defend the blue slip process. That letter was sent on March 2nd, 2009 to President Obama and our colleague, Senator Leahy, who was then the chairman of the Judiciary Committee. The letter clearly indicates that Leader McConnell and his Republican colleagues believed that nominations should not go forward without blue slips having been returned. That was when there was a Democrat in the Oval Office. A Democrat held the gavel in the Judiciary Committee. They had the power to tell the Republicans in the minority to get lost, take a hike. Democrats did no such thing. We upheld the blue slip tradition on this side of the chamber, where my good friend Senator Merkley and I sit. We went along with the unanimous request from that side of the chamber in honoring blue slips. There were no hearings on judicial nominations when a Democrat held the gavel in the Judiciary Committee when neither home state senator had consented. In fact, as Judiciary Chairman Senator Leahy has emphasized, he went above and beyond what several committee leaders before him had done to respect the rights of the Republican minority. Somebody watching in the gallery or on TV, somebody who's hoping to see the Congress pick up again on what I've described as principled bipartisanship, is probably hoping to hear Republicans are operating with the same bipartisan comedy now that they're in power. Those people are in for some serious disappointment. If the Senate approves the Bounds nomination, it will be the first time in more than a century that a judge has been confirmed without a blue slip from either home state senator. The fact that Mr. Bounds wrote these appalling things I've described ought to at least have slowed this nomination down to be considered. For him to have hidden the writings is disqualifying. I don't think the matter can be ignored or wished away. And the fact that these writings are embarrassing and reflect poorly on him in retrospect does not in any way give him a license to conceal them. In my view, my colleagues in the majority ought to look at this issue the same way. The Republican majority, working hand in hand with the Trump administration, is now on the verge of breaking a century of bipartisan tradition to seat a nominee with very, very serious red flags. And in fact, Chairman Grassley's now held hearings on 4 circuit court nominees who didn't have blue slips from one or both of their home state senators. Recently, Leader McConnell changed his tune on what the blue slip was about. He was quoted as saying, and I quote, "The blue slip ought to simply be a notification of how you're going to vote, not the opportunity to blackball." I've got 2 reactions to that. Senator Merkley and I have been called a variety of things over the years, but I don't believe anybody has ever said we're interested in blackballing people. We're interested in doing our jobs. We are interested in carrying out our constitutional responsibilities and our constitutional responsibilities to our constituents. Second, blue slips have never been simply an indication of how senators will vote, and Mr. McConnell, Leader McConnell, knows it. The letter he and his colleagues sent in 2009 is proof. So to invent this new interpretation of how the process should work demonstrates, as I've indicated, the Republican majority has changed the rules of the game. My colleagues on the other side ought to be aware of this new responsibility. Because of how the administration, the majority leader, and the Judiciary Committee have handled the Bounds nomination, this, colleagues, is going to be the end of the blue slip process. This is lights out for a process that ensured fairness for each senator. And I'd wager that when the next Democratic administration comes in and Democrats hold the gavels in the Senate, a Republican leader demanding a say in judicial nominations is going to find it hard not to be treated like a takeout menu shoved unsolicited under the doorway, straight to the dustbin. Mr. President, I have outlined the letter that my Republican colleagues sent to President Obama in 2009. It talked about a shared constitutional responsibility, but the administration seems to define advice and consent as senators rubber stamping whatever nominations are sent their way. This is a historic moment, and I think a sad one. It's part, as I indicated, of a larger context, a part of a pattern of the majority violating norms, misleading the public, bending rules to their absolute limits to reshape the judiciary and seat judges that are far, far, far from the mainstream. Justice Scalia passed away unexpectedly with 237 days left in President Obama's second term. The process of deciding on a nominee to fill the open seat, President Obama did something he didn't have to do, something that upset many Democrats, progressive Democrats. He specifically chose a moderate nominee as a show of good faith. After all, in 2010, when another seat opened up, my friend who chairs the Finance Committee called Justice Garland a fine man, a consensus nominee. What a difference a few years makes. Judge Garland didn't even get a hearing in 2016. The Republican majority in the Senate ran out the clock on his nomination. Now, when Republicans control the White House and the Senate, they changed the rules here in the Senate so they could confirm Supreme Court justices without needing a single Democratic vote, a clear double standard. Mr. President, I'm going to ask that the remainder of my remarks be put in the record and close with just one last point. There are values on the line now that are important to the people of my state and to Americans, particularly the right of all American women to make their own choices about their reproductive health and their health care. The Roe case is settled law. It's been that way for 45 years, but now there is really a prospect of it being turned back, and the poor and the vulnerable have the most to lose. These are all issues that are part of the broader context I've wanted to address here tonight. I'm not sure if Senator Merkley was here at the particular moment. I see my colleagues, because my time has expired. My colleague's been very patient. We had a bipartisan selection committee for judges in our state. The late Mark Hatfield, Gordon Smith, Senator Merkley's predecessor, Democrats, Republicans, all of whom said that we don't want to bring the same vitriolic discourse to judicial selection that constitutes so much of the public debate today. What we sought to do in the Oregon congressional delegation, Senator Merkley, Mark Hatfield, Gordon Smith, is we sought to buttress the public trust. What we are seeing now in Oregon and with the judges that are being given such short shrift, such unfair treatment, in my view, raises the question of whether the current structure of America's courts can survive. That's what's at stake in these votes. And I think what we are discussing tonight is going to be only a preview of the tense debate on the judiciary that's sure to come. I think we're capable of better. Oregon has shown it for 2 full decades as it relates to judicial selection. I urge the Senate to return to that kind of collegial process, exemplified by the Blue Slip, exemplified by the Oregon Bipartisan Selection Committee, and until that happens, I will have to urge a no vote on the Bounds nomination. And with that, I thank my colleagues for their patience, and I yield the floor.
Mr. President.
The senator from Pennsylvania.
Thank you, Mr. President. I rise tonight just not even, I guess, about 24 hours since the news broke across the airwaves about what the president was saying and what he was not saying in Helsinki with Vladimir Putin